Hey everybody, welcome to Prop 65 in 2018, the changes you'll see on warning labels and how to keep your company in compliance. Thanks for patiently waiting, so let's get going here. I'm your host Jay Sailing and I'll be moderating today's webinar. First off, I'd like to thank all of you for joining us today. This webinar came about from a ton of inquiries from our clients and really the compliance industry as a whole regarding the new Prop 65 amendment. We figured it'd be a great opportunity to get some experts around the table and discuss Prop 65, dissect the new amendment, and share some best practices that we've found in terms of California Prop 65 compliance. So very quickly, here's a quick timeline of today's webinar. We're going to first hear from Jack Schatz on the evolution of Prop 65, then Wayne Rosenbaum on a comprehensive overview of the new amendment, and then finish things off with Zephan Spett on the Prop 65 compliance process. So I'm going to quickly build on those brief introductions. To start things off, again, my name is Jay Sailing. I'll be your moderator. I've spent the last 3 years here at Source Intelligence as a business development manager. My main focus is really to bring awareness to our growing platform of state, national, and global compliance programs. So our mission at Source is really to bring transparency and visibility to the supply chains of companies around the world. We do this really by facilitating communication for companies to collect and analyze data for now over 54 compliance programs that include human trafficking, conflict minerals, REACH and ROS, and of course today's topic, Prop 65. All right, let's get into this. So here's a few housekeeping points that I want to bring up that should help you throughout the webinar. All PowerPoint slides and a recording of this webinar will be sent to every registrant once the webinar is complete. Due to a high volume of questions we've received also during the registration, I'm going to give the speakers a moment to answer all the inquiries after the webinar, and I'll be sending out a follow-up document that answers all the questions from the speakers themselves. If you have any additional questions throughout the webinar, please feel free to type them in the chat box in the GoToWebinar control panel. Also, if you'd like to stay up to date on all things compliance, don't forget to check our resource center and make sure that you join our blog subscription community. So as I mentioned before, I'm really excited to say that we managed to bring together some of the top experts in the Prop 65 compliance field. First up, we have Jack Schatz. Jack will give us an overview of history and evolution of Prop 65. So Jack's a publisher of Prop 65 News and also the Prop 65 Handbook. He began his career as a journalist in 1982 and then later took an interest in chemical safety. His first involvement in Prop 65 came in his participation in the groundwater litigation concerning a former rocket facility. As a note, Prop 65 News is one of the original California Prop 65 publishers and has been continuously providing value since 1987. Next up, we'll have Wayne Rosenbaum join us to go over the new amendment to Article 6 and outline the industry-specific requirements. If you're involved in online retail, you'll definitely want to pay close attention to his industry-specific requirements for e-tail, e-commerce, online retail, all the above. So Wayne's a partner at Environmental Law Group, where he focuses around developing compliance strategies, implementing compliance solutions, and assisting clients in regulatory compliance program defense. And then finally, we're going to wrap things up with Source Intelligence's own Zephan Spett. Zephan's our Director of Compliance Product Research here and is our in-house expert on all things regulatory compliance. Zephan's background in chemistry and product testing has really led him to be a critical part of our California Prop 65 program development team, so we're happy to have him join us today. So now that all the intros and housekeeping is done, let's get into our first speaker. Jack, you have the floor.
Hello, everyone. I'm happy to tell you about the history of Proposition 65, which goes back for the past 30 years or so. It will be 31 very soon. And I'm often asked how the situation with Proposition 65 came about, And to understand that, you have to understand what was happening in the 1980s with the environment and with the government agencies that were tasked protecting the environment in California. So the Prop 65 initiative was developed because there was a lot of mistrust about what the California agencies like the Department of Toxic Safety and several others were doing to protect the environment and to protect consumers and workers who were often exposed to hazardous chemicals. So the initiative sought to have a very strict set of rules, and it was based on a movement that was going on throughout the country called the Right to Know movement, where people who were working in various occupational settings did not know what chemicals they were being exposed to at their workplace. The same was true for chemicals in groundwater and in drinking water. If you were to work at one of those facilities in the 1980s and you asked what chemicals you were being exposed to, they wouldn't tell you. And if it was a defense plant, which there were a lot of those active during that time, you would be told that's classified. So this is the backdrop of how Prop 65 came to be. And what happened is that when it went to the ballot, as an initiative, it won by 2/3. But many of the voters, all they knew about the initiative was that it would save drinking water from contamination. Those same voters, at the time that they voted for Proposition 65, didn't have any idea of how dangerous some chemicals that they thought were benign were, especially in an occupational setting. And that is probably the first big win from Proposition 65 is when workers got the protections that they needed working with hazardous chemicals that they otherwise would have no idea what they were, and at least they would know what to do about it. So one thing I hear often from people who don't know the history of this initiative is that it's a stupid law because of things like the bounty hunter provision of the law, which is revolutionary. It's one of the few in the United States like it, and it's the most used and the most reviled, at least by businesses. In some ways, the voters, when they cast their ballots back in 1986, weren't exactly sure what they were getting. But Prop 65 has helped many consumers and businesses to be more environmentally friendly, let's say. But it has also had its excesses as well. Proposition 65 is basically a public health law with health protections written into the statute, yet its implications drive a broad array of changes in the occupational, consumer, and environmental protection arenas. Because Prop 65 is not enforced in the traditional sense by a designated regulatory body acting through administrative rulemaking and or permitting processes. Instead, Proposition 65 empowers both private as well as public prosecutors to enforce its statutory terms solely by lawsuit. And this is the most controversial feature of Proposition 65, which empowers anyone who wants to be a bounty hunter. One other feature of Proposition 65 evolved at a time when businesses were coming to grips with the new law and having trouble complying with it. And one of the things that they did not want to do was to name, if they were to do a warning, they did not want to identify the chemical or chemicals that were present. This is been the case since at least 1988. And in 2013, Governor Brown made it his personal business to make sure that there would be changes to Proposition 65, especially to the clarity of the warnings. One thing that was on the top of his agenda, which is going to be happening soon, is that he wanted to be certain that if a company was posting a warning or conveying it in any other way, the warning would have to identify at least one chemical that is the cause for the warning. I believe that this is a good thing, though a lot of the business community is very afraid of this provision, where they have to actually disclose what chemical it is that's in their product. But I've always felt it's better to say it, to disclose it, rather than to make it a secret, which I think could do actually more harm for businesses who won't say what the chemical is. Proposition 65 has gone on to be a lot more than just a safe drinking water statute. It has become a statute that regulates safety in products as far as chemicals are concerned, and it has helped spawn the concept of right to know, which today is taken for granted, but back when the statute was originally went to the ballot and was adopted was a new idea completely. Bounty hunters are still controversial, probably will be for as long as the statute is on the books, because it gives Proposition 65 a sense of Wild West and frontier justice.
Thanks, Jack. That was really good. A lot of information to take in there, so I just want to remind people that all slides and a full recording of the webinar will be available once we wrap up here. And I also see quite a few questions coming through. As a quick reminder, all questions will be answered in a follow-up document that will be released in the coming days. So let's get into our next speaker. We have Wayne Rosenbaum. Wayne, take it away.
Hi, my name is Wayne Rosenbaum, and I'm a partner with the Environmental Law Group. And today we're going to talk about California Proposition 65 and the new clear and reasonable warning standard. In August of 2016, OHIA adopted amendments to the regulations regarding what constitutes a clear and reasonable warning. In December of 17, OHIA then adopted some clarifications to those regulations. Okay. These regulations will then become effective on August 30th of 2018. However, businesses can begin using the warnings that conform with the new regulations immediately. The regulations are broken into two pieces. Article 6, Subchapter 1 consists really of the mandatory provisions, including definitions of terms and applicable warning standards that apply to everyone. Article 6, Subchapter 2 then provides non-mandatory safe harbor methods of dealing with how we provide a clear and reasonable warning to consumers, to people within the environment where our product is used, or to employees. The question that always comes up is, when's a warning required? Well, the regulations say that if the product or activity exposes persons in Californians, 1, to a chemical known to the state to cause cancer or reproductive harm, 2, at a level of exposure above the safe harbor level, or 3, for which a safe use determination has not been established, then a warning is required. The warning regulations don't address the question of whether a warning is required for a specific product. Rather, the regulations provide guidance on how to provide the warning once a business has made the determination that a warning is required. And that always leads us to the question, well, how do I know whether a warning is required? Is testing required? The warning regulations do not require a business to perform any testing. However, as a factual matter, the manufacturer, importer, distributor of the product is responsible for determining if a warning is required. And the question then becomes, how would one determine whether a warning is required without testing? Why do we want to test? Well, we want to determine whether this product requires a warning or whether it falls into what's called the safe harbor. The safe harbor warning methods and content in Article 6 are deemed by OHIA to be clear and reasonable. That is, if you follow what's in the regulations, you are deemed to be in compliance. Businesses can choose and have in the past chosen other warning methods and content. However, that puts the business at risk in the sense of having then to defend that their warning is clear and reasonable. So adding language like may or might to the warning, as an example, throws one into a situation where the question becomes, is it clear and reasonable? Placing the warning in a location that isn't necessarily obvious to the end product user or consumer may throw into question whether the warning is clear and reasonable. A consumer product covered by a court-approved settlement, however, is always deemed to be clear and reasonable. The next question that always comes up is, well, then, who's responsible to provide this warning? And OHIA's new regulations have made clear that they are placing the primary responsibility for providing warnings on the product manufacturers, producers, packagers, importers, suppliers, or distributors, not the retailers. For consumer products exposures, businesses in the above categories must either, 1, provide a warning on the product, or 2, provide a notice and warning materials to the authorized agent. That is the retailer who is ultimately going to sell this product to the consumer. The retail seller is responsible for placement and maintenance of that warning if A, it has been provided, and B, if the retail seller agrees to take on this responsibility. Often the question then comes up, well, really, I don't manufacture a product that gets sold directly to consumer. I manufacture a component within that product. I manufacture the circuit board within the laptop, but not the laptop. How do these regulations affect those folks? Well, a company that manufactures component parts or ingredients that include any of the listed chemicals can comply with their obligation to warn persons who can be occupationally exposed to the bulk product by providing a warning consistent with the new regulations. That is, suppose I manufacture toluene and I sell someone else a drum of toluene that they're going to use in their printing process. I am the manufacturer. As the manufacturer of that drum of toluene, I need to provide a warning for that drum. However, the company would only have responsibility for a consumer warning if it has knowledge that the end use of the component part or ingredient can expose a consumer to the listed chemical. And this is important because, again, if we go back to our hypothetical regarding the circuit board and the laptop, the question of responsibility turns on whether or not the manufacturer of the circuit board has knowledge that, or reasonable knowledge, that it's possible that the end user is going to take his or her laptop apart and then go play with the circuit board. Once it's been determined typically by the manufacturer that a safe harbor warning is required, the next question then becomes, how do I provide it and what does it look like in terms of content? First of all, there are certain type size requirements depending on the category of exposure covered by the safe harbor warning. And while I'm not going to go into all the details here. You can certainly go to the regulations and look to see what size, how big the print or the type must be. A good example is if we're going to use what's called an on-product warning, the minimum type size is 6-point and can be no smaller than any other consumer information supplied with that on that particular product or associated with the Prop 65 warning. There are lots of questions that have still come up on that issue in terms of does something like made in Mexico or the name of the product constitute consumer information, which would then fix the type size. And typically, if you look through the regulations, they do divide information into two categories. We have also found that if you have a question on that issue, OHIA has been helpful in determining what category that particular statement might fall under. In terms of the methods and content, again, the regulations describe product-specific warnings that provided on a posted sign, shelf tag, etc., within the consumer store may be appropriate. Product-specific warnings provided via an electronic device that automatically provides the warning to the purchaser prior to purchase may be appropriate. A warning on labels that comply with the content requirements in the new regulations, namely the warning symbol, the signal word warning, and the applicable warning message, is certainly appropriate. There is now also an on-product short form warning that does not require you to identify a specific chemical or compound, but simply to state that the product is potentially can cause cancer and or reproductive harm. And many manufacturers are beginning to look to that as a preferred methodology by putting that warning on the product. Now, there are some restrictions that it must be either on the product or on its immediate packaging, but this is something you may want to consider looking into. Things that won't work. Warnings in the owner's manual. In past iterations, we have considered that a warning that's put into the owner's manual in similar form and content to other warnings in the manual might be sufficient. These regulations make clear that that's not a sufficient warning. General warnings, standalone warning at a public entrance, purporting to cover all possible consumer products or exposures within the facility, is not an adequate warning. So again, we want to make sure that the warning is placed in the appropriate location, and two, that it has the necessary information. More and more of our sales are now over the internet. And so this new set of regulations does provide us with some good guidance on internet warnings. It's clear that warnings are required for purchases made over the internet, and the regulations lay out several options and what must be included. One of the two interesting factors here is that if you use the on-product warning on the product per se, you may use the same on-product warning in your internet sales. The second question is, when does the warning have to be given? Well, the warning has to be given prior to the actual consummation of the sale. And so some of our clients have determined that the best way to do that is to have the warning as a pop-up whenever a California zip code is entered into the ship to information. Catalog warnings. Catalog warnings are very similar to, or in fact identical to, internet warnings. However, they're a bit more difficult to implement because there is not this opportunity to have a single warning or a warning that pops up based on the ship to address. What the regulations here would require is that in the catalog, each product that is subject to a Prop 65 warning must carry that information on the page along with the the product information. This may spell the death knell of catalog sales, but certainly is going to become an issue. The other issue is where you have a catalog that where you cannot purchase directly from the catalog, but really you have to call a phone bank to place your order. And there the question becomes, can you get the warning through the phone bank? We believe that if the operator taking the sale provides the warning based on the ship to address, that too would, much like an internet sale, would conform with the regulations. The new regulations also require the use of a warning symbol, which is this yellow triangle with an asterisk or a exclamation mark in the center of it. There are various forms of this. If you don't print in yellow, you do not have to use yellow. The size may vary depending on your other warning requirements, but in each case where you're placing a warning either on the product or on the associated materials, this symbol must accompany the warning. And the regulations only require that the warning symbol be yellow if, as I mentioned before, the color of the yellow is used in the other printing activities of the product. How about warning type and size? Well, we've talked about for on-product short form warnings, the type size may not be less than 6 point. For others, it must be requires that the safe harbor consumer product exposure warnings on the label be prominently displayed with such conspicuousness as compared with other words and statements and designs or devices on the label or labeling or sign as to render the warning likely to be read and understood. It is much like beauty. It is certainly within the eye of the beholder. But I think if we take the same standards that apply to the on-product warning and apply it to other types of warnings, that seems to be, would seem to bring one into the safe harbor. The other question that comes up frequently is when you are providing a warning that requires a chemical name, which chemical name should I choose if the product has multiple chemicals that require a warning? The first thing that comes up is clearly you need, if the product contains multiple chemicals that require a Proposition 65 safe harbor warning, the warning need only include one of those chemicals. However, where the business is providing a warning for both cancer and reproductive toxicity, the warning should include the name of one of those chemicals, which reflects both the reproductive harm and the cancer risk. Coming back a bit to this short form warning, as I mentioned before, it must be applied directly to the product or its immediate packaging. It does not require the identification of specific chemicals. There is no limitation on the product size, and I think that's important. Originally, people were thinking that you could only use this short form warning where you had a relatively small product and therefore you didn't have room for all this additional information. No, it can be on a refrigerator. The warning content on the short form warning must be in a type size no smaller, however, than the largest type size used for other consumer information. And I would refer you back to the definitions in Article 6 as to what defines consumer information. It is not as clear as one might think. As an example, is a shoe size consumer information, or is the locus of manufacture consumer information are questions that you need to look at based on that definition. One of the other issues that comes up frequently is what languages must I provide the warning in? And the answer appears to be that if any of the other information being provided for this product is in some foreign language, then the warning must also be provided in that foreign language. This may be somewhat problematic because we see more and more products that have consumer information or product information, say, both in English and Spanish. It's not clear as to whether or not, for example, if I buy an electronic device and along with that electronic device, I have directions in English and Spanish and German and Italian, do I have to give the warning in all of those languages? And the answer to that question really revolves around what constitutes consumer information or product information as defined by the regulations. Many businesses are also concerned with environmental exposures. This is not an exposure to a specific product per se, but rather that the product being sold can create an exposure to people in the area of the product. A good example might be at an airport where you have jet fuel that contains compounds known to the state of California to cause cancer and is in the air around the facility. Or for light aircraft where you have leaded fuel, and that as you're burning that fuel, the lead kind of comes off into the atmosphere. A couple of changes or clarifications in terms of these regulations for those kinds of situations. One, that we now need to have a map showing where the exposures are likely to occur. That is, we cannot just put a sign up in front of our airport and say, "Ha-ha, there's an exposure here." We need to show where the exposures might occur, and that the warning be provided close enough to the source of the exposure to be meaningful. So I think this is going to cause us, in addition to looking harder at the language for these kinds of exposures, also where do we post the exposures and how do we incorporate that map? Another area of concern sometimes is occupational exposures. If a business is determined that the only exposure is exposures that are covered through OSHA, then the OSHA warning is deemed to be sufficient for the Prop 65 warning. And that's typically done through safety data sheets, what we used to call material safety data sheets. Okay, that is, safety data sheets may be used to provide the warning, but they are not necessarily a safe harbor. So again, we want to look to see, is that sufficient? Have we provided a clear and reasonable warning? Typically, some of the things our clients do to supplement the material safety data sheets is, as an example, to put warnings up on the employee bulletin board where we have our wage and hour information, to put information into their pay envelope, or certainly during routine health and safety training activities. So there are lots of ways to supplement. The material safety data sheet is a start, but it certainly needs to be supplemented. And with that, I will turn it back to our sponsor.
Thanks so much, Wayne. That was a really solid overview. So I know that we don't have too much time left, so I am going to transition it right over to Zephin. Zephin, you have the floor.
All right, thank you for the introduction, Jay. So I'd like to walk you through right now some of the challenges that companies often come to us with regards to California Prop 65 compliance. There's a lot of moving parts to Prop 65, and of course we've heard some of those today explained and how the updates to the new Prop 65 language for 2018 may affect your company. And I just want to go over a little bit about how all of us as Source Intelligence are here to really help you kind of go through the system with as few pains as possible. There's, of course, several different things happening when we're working for or towards Prop 65 compliance here at Source Intelligence. First thing we want to do is we want to go ahead and work with you on product scoping. Of course, not all products will necessarily fall within the realms of a concern for Prop 65 listed chemicals. And understanding that and which ones are more likely to be risky than others is a very important thing to not only streamline the process, but to also make sure that we get as much timely information to you as possible. Supplier engagement, of course, is also another tricky aspect of Prop 65, because a lot of times as you're talking to even your immediate suppliers, they may or may not understand Prop 65 or how they have to help you to fall within compliance. Perhaps they're in another country. They speak a different language. You only communicate with them through email or some other means, as opposed to direct verbal confirmation of, information trading hands. Perhaps they're in a different time zone and can be difficult to get a hold of. All of that comes into play when we utilize our call center, which is open 24/7 and speaks over a dozen languages. So we're really here to help streamline that aspect as well. And of course, that dovetails into data collection and analysis. These can be very tricky things for most of our customers to handle when they're talking about thousands of different products, both old products and ones that they're trying to develop for the next 6 months to a year out. A lot of times that product development can take a lot of different twists and turns when you're talking about the different materials that suppliers may be able to provide you with in a timely fashion for the right cost, or in this case, make sure that it falls under the right compliance. Prop 65, of course, has over 900 chemicals currently in its list, and that's only going to continue to grow. So being able to analyze all of the data coming in quickly and efficiently is very important. That chemical identification, in fact, can be very overwhelming for a lot of companies that still work on old Excel sheets, trying to compare one table to another. And our platform streamlines that process by having everything in just one simple cloud-based window that you can access from many different devices, and enables you to, in fact, store not just the chemical information, but also any documents that are uploaded as well in one easily accessible area. And finally, all of this information will help you to figure out what the proper labeling or decision about a current product line you have to make. With Prop 65, of course, we've learned there's a lot of different labels that are coming out. Choosing which one or choosing whether label or not, very important. So having the right data at your fingertips, being able to easily access it, is critical for making those decisions. When we're talking about product scoping, a lot of times what we're talking about is what are the base metals, materials that make up your particular product. And understanding those is very important for being able to, right off the bat, being able to assign kind of high-level risk to certain things. We know that recycled metals, for example, may contain lead and other impurities. Just like with a lot of plastics, there's plasticizers in them that give them the functionality that they need in order to operate, but again, can also pose an issue when it comes to California's Prop 65. One of the things to keep in mind too is whether or not we want to market or help you in your marketing of this product, either to general public or to trained professionals. All of these things can be very important when it comes to whether or not you have to label, and if so, what that label looks like. Gathering information, as I said, can be very tricky if you're dealing a lot with vendors that are over in Asia or in parts of the world where English is not their primary language, where perhaps they are on a completely different time schedule than you. Perhaps they're not aware of Prop 65 at all. And so we utilize a 24/7 call center housed here in Carlsbad, California, that speaks over a dozen languages and can reach out not only for questions about information, if need be, but also handle supplier education and documentation. One of the things that we found is that we have customers who their suppliers do want to help, and in fact, they are eager to give information once they understand what is this being asked of them. And being able to sift through that can be a lot easier when you have someone who speaks their language and is able to reach them on their time, normal hours of business. So our call center, again, is a very useful tool for that. So in conjunction with our platform, which is an automated emailing and tracking system, makes for a very effective set of tools. Gather the data that you need. Now, once all that data starts to come in, especially if you have hundreds, even thousands of products, the aggregation of that data can become very challenging for people who are only operating by an Excel sheet or some other means. And our platform does a great job of gathering all the information, putting it in one place, and being able to sort through it so that way you're able to leverage the information coming out of it in an effective manner. It does this by taking all of the chemical information coming in, or responses to questions, and being able to list them as important or high priority or potential issues. This is done through a series of kind of call outs using flagging or other messages within the platform to notify you that you need to take a look at this and there may be further steps required. We also have the ability, as I said before, to collect documentation. Now, this documentation is going to take many different forms. That can be in certificates of compliance, which of course have a lot of variety to them out in the industry, but they typically revolve around a particular product or product line that may have a listed chemical according to Prop 65. They can also be laboratory test reports, whether it be ones that you have commissioned that we want to upload on your behalf, or that your suppliers have done as part of their due diligence. And then finally, we have things such as manufacturing contract agreements. These we don't normally see for Prop 65, although they do occur. We typically see these more for other regulations such as REACH and ROS, other international regulations that we assist companies with. Now, the data collection that we do, again, if we're going through a full material declarations data gathering program, that's going to help us to identify individual chemicals or materials within your products. And we do this so that way we can get down to nanograms, in some cases, worth of data on a particular product or product line. And when we're doing that, we're digging down through the tiers. The platform is actually designed so that way if we contact a supplier and their distributor, or they're merely putting together a subassembly, they can then forward the request for those chemicals down to their suppliers and so forth until we're getting chemical information similar to what a bill of material might be. And that way we're getting a wealth of information at the end about a lot of different things occurring within your products that you may not have even realized because they're several tiers down in the supply chain. We then use that information to then help you come up with conclusions as to what type of label would be most appropriate, or if you want to change something about your product build or formulation to eliminate that as a potential risk or labeling requirement. Our trained staff of program managers, of course, are always available to field any questions you may have, as well as myself. Again, thank you for your time, and I'll turn this back over to Jay.
Thanks so much, Stefan. All right, everyone, so that looks like we're out of time. I just quickly want to reiterate that all the on-demand features of this webinar will be sent via email to all the registrants. I'd like to once again thank everyone for joining us. I'd like to thank the speakers for giving us a ton of insight on this upcoming amendment. If you have any questions or concerns, please feel free to reach out to us. Everyone will receive a follow-up email with a few resources that should guide you further, along with an opportunity to set up a one-on-one time with an expert to speak about your Prop 65 needs, so be on the lookout for that. And that should wrap things up. Thanks again for being with us, and have a great day.